Okay, today is Tuesday, April 1st, 2025. This is Children in Justice. It's dawned on me it's April Fool's Day. You can all leave now. Sorry. We're now going to be talking about a concept that's a fundamental legal concept. And we talk about the law a lot, obviously, in this class. And this concept is related to witness testimony and the reliability of witness testimony. Specifically, it's a rule called the Hearsay rule, Hearsay. And it's important because it comes up in the area of children in the courtroom and children in the justice system quite often. In my experience as a prosecutor, many moms or dads or teachers would come to me and they'd say, hey, can you just introduce the video of the child's interview? Can you just introduce the statement that I made? And the answer in both cases is no, because it's hearsay. And we'll get into some detail in a moment and on Thursday as well into what we mean by hearsay. But it is common to misunderstand what's admissible in court and what's not admissible in court, especially among lay people. Lay people are people who are not versed in the law, who are not lawyers, who are not courtroom professionals, if you will. So you have a bit of a heads up on the hearsay rule because I taught you with great detail about the Sixth Amendment right to confront the witnesses against you. We even saw Anne Boleyn and the video account of her trial and the fact that she was convicted solely on the basis of sworn statements, written statements. No witnesses came in and testified. She was condemned to die and ultimately executed based upon hearsay. And also fraud and deception and skullduggery and all kind of bad stuff orchestrated by Cromwell, the king's confidant. But in any event, we're concerned about hearsay, okay? Hearsay. And it happens a lot with children in the justice system because the expectation is, by many, is that the child's statements to mom or to the nurse or to the friend or to the aunt or to the school guidance counselor or to the detective that may even be recorded on video is likely admissible, that it's a substitute for the child having to come to court. Again, as I said a moment ago, moms say, can't you just play the video? And again, the answer is no. You can't just play the video because it's hearsay. Hearsay. So I'll give you the law school definition of hearsay right now, but then we'll deconstruct it so you all understand it much better, perhaps, than you do now if you understand it at all. But hearsay is a statement made outside the courtroom. So put a 1 in your notes and put statement outside the courtroom. That's the first element of hearsay. Somebody, some human, some person made a statement not in the courtroom, outside the courtroom. Okay? And then somebody's trying to get the judge or the jury to hear that statement inside the courtroom. But it's not the person who said it. I'll say it differently. Hearsay is a statement made outside the courtroom, a statement. Somebody said something outside the courtroom, and the person who repeats it in the courtroom is not the person who said it. It is repeated in the courtroom by someone other than the person who said it outside the courtroom. This will make more sense when you look at it with real-life examples. But if you want to look and drill down immediately to child abuse, imagine the child, the 6-year-old, tells her teacher at school that grandpa comes in her room at night and scares her. The counselor at school heard the statement, and the lawyers want the counselor at school to come and repeat that statement in the courtroom. Would that be hearsay? Let's think about it. Where was the statement made? At the school. So it was a statement made outside the courtroom, and it's being offered in the courtroom for the jury or the judge, right? It's being offered in the courtroom. Is it being offered by the person who said it? No. The counselor wants to come to court and say what the kid told her. Not okay. Violates the rule against hearsay. Again, Hearsay is a statement that's made somewhere else, not in the courtroom, okay? And that statement is repeated in the courtroom by someone other than the person who said it. We call that person who said it the declarant. D-E-C-L-A-R-A-N-T. I do declare. They said it, Gone with the Wind. Hearsay is a statement made outside the courtroom, offered in the courtroom for the truth of the matter asserted by someone other than the declarant. That's the law definition. All you need to know is the person who said it ain't in the courtroom. Some other person is repeating what someone told them. I like to think of hearsay conceptually this way. The best witness rule, I made that up, but it's really the best witness rule. If the little girl in my hypothetical is the one who lived some interaction with Grandpa, if she was in fact scared by Grandpa, and she told that to the counselor, and we want the jury to believe that the child was in fact scared and something happened that made her scared. We want the jury to hear it or the judge to hear it. Who's the best witness? The child who lived it, who experienced it, who was there at the time and place, or the counselor from PS18 who works from 9 to 4, is going home to her family? Who's the best witness to describe what someone experienced? The person who lived it, the person who experienced it, right? The best witness in my hypothetical is the child, not the counselor, the child. And again, it fits the definition of hearsay because the child made the statement at PS18, and it's repeated in the courtroom by someone other than the person who said it. Who's the person who said it? The child. Who's in the courtroom? The counselor. Counselor is not the best witness to tell what happened because he or she did not live it. They didn't experience it. Okay? There's a reason why the courts for centuries don't like hearsay. Why this rule of evidence has survived for many, many years, hundreds of years. It is a gift from England to the United States, the prohibition against hearsay. And the reason is twofold. Number one, we don't consider hearsay reliable. Because what happens is, when you tell somebody about what you experienced, oh, I was at this party Friday night, oh my God, they were doing lewd shots, and then one guy was dancing on top of the table and he fell and I think he cracked his head. Did you see that? I saw the whole thing. The person he's describing it to wasn't there. Didn't see the luge. Didn't see the guy fall off the table and crack his head. He heard it from the guy who was there. So now he has that in his memory banks. He heard that from his buddy who was actually at the frat party. He's now going to repeat that story to someone else. But guess what? He's been to frat parties before. So his expectations about what a frat party looks like, what the table looked like, what a crack in the head looks like, right? What a luge looks like. Was it an ice luge or some other kind of luge? Do you even know what a luge is? Do I know what a luge is? I don't know. I may describe what happened, having heard it from someone else, through the filter of my expectations and brain power and experience with frat parties and luges and all that kind of stuff, right? Imagine that second person tells it to a third person. So you can appreciate how when a person who lived something, who was at the frat party, saw the luge where you drink shots on some ice cube or a big wedge of ice, and some dude climbed on a table and fell and cracked his head. One guy lived it, saw it, and was there, was an eyewitness. The next guy heard about it from the original guy, the declarant, right? He filters it through his life's experience, his expectations, frat parties he attended, what he thinks the word table means, and then he repeats it to a third party. And that third party goes through their brain and their experience. And you can see how, almost like making a photocopy over and over again, it begins to degrade and change in quality and texture and look. Go ahead, Jenna.
So basically it's like the game telephone.
Well, telephone. Did you hear me whispering about that in the back before? Yes, that's exactly right. It is similar to the game telephone, which I've never played with undergrads, but we're going to do it today, just for the heck of it. 20 years I'm teaching here, and as Jenna points out, and as past classes have pointed out over and over again, it's kind of like the game of telephone. So what we're going to do now is, and if you don't like someone whispering in your ear, then just give a thumbs down when one of your classmates approach you. But we're going to start with Nico, and he's going to share, and we're going to end with Jenna, since she brought it up. Okay? So Nico, share, and go in the back row. You remember the statement? Did you review it again? Okay, go ahead. Whisper quietly. We don't need neighbors to hear. In the ear. And again, if you don't want somebody in your space, I get it. Down, thumbs down. We don't need any, whatever.
Yeah.
It's 2 sentences. Okay? Quiet. Shh.
Okay.
All right, let's get back to, we played telephone, it kind of worked, kind of didn't, but it's all good.
Wasn't the whole point for that?
Right, but if it's sabotaged, it doesn't really make the point. It's sabotaged. For posterity, the quote was, say it again, because I'm recording this.
Those who cannot learn from history are doomed to repeat it.
And what did they come out to?
No, Russo said not to study and that history will repeat itself.
Del Russo said not to study it, and then history will repeat itself. Listen, hey, let me tell you something though. There is a lesson here. Indeed, don't study in history. Yes, no, it's a great quote, thank you, but that's not what was said. But here's the thing, that there's a lesson from that. Someone along the route, okay, put that in there, probably, I don't know how it got there. There's no nexus to the original statement, so I suspect it was purposely put there, but that's okay. Because sometimes it's not people getting it wrong through repetition, and repetition degrades information and recollection and filtered and all that. Sometimes someone has a bias or a motive or an interest, okay, to change the world, to change facts, to tamper with the information, right? And we'll talk about that in a moment. The bottom line is it's not reliable. What she said, whether someone purposely tampered with it or sabotaged it, as I called it, or not, it's not the original statement. It degraded and it was tampered with. Recollections get tampered with. Children get interviewed by people who might put ideas in their head. If you take my forensic interviewing class, the whole course is about the impact of investigative interactions with children and parental interactions with children on children's memory error. So anyway, so we've learned that the information degrades the more people it goes through. And that means it's unreliable. Reliability is one of the reasons why we don't like hearsay. We consider statements made to other people, okay? And that other person, the one who didn't live it or experienced it, coming to court to say what happened, we consider that statement unreliable. If Carly came to court to tell us what Nico said, we don't need Carly. We need Nico. Nico's the best witness. He's the one who lived it. He's the one who interacted with me. He's the one who was prepped by me. He's the one who has the paper with the quote on it. Carly heard it through 12, 15, 20 different brains, 20 different recollections, 20 different life's experiences. That doesn't mean hearsay is always wrong or it's always not admitted in the courtroom. Sometimes there are exceptions, which we'll probably talk more about on Thursday. Okay? But the general rule is we don't like hearsay because it's considered unreliable, number one. When it goes through people's memory banks, it gets tainted a little bit. It's influenced by our experience. To go back to the example when I gave you about a guy who was at a frat party and they were doing luges, and the guy got on a table and he fell down and he cracked his head and the ambulance came. Okay, he tells it to his buddy who wasn't at the party, and that guy's called to testify in court. Well, like I said, he's been to frat parties before. He may have heard of the luge before. He may have drank from these things before. But maybe it's not the one that he has in his brain. You know, maybe he thinks it's an ice one, and this one is made with wood. I have no idea. I don't do shots on dirty things at frat houses. But my point is, his perspective, his brain, his life's experience has the potential to impact his understanding of what the other dude told him. The other dude who was at the party is the best witness. He's the one who would have come to court. Here's the other thing, though. The number 2 reason why we don't like hearsay in the criminal courts, and we talked about it when we talked about the 6th Amendment right to confront the witnesses against you, okay? Hearsay, okay, violates the 6th Amendment right to confront the witnesses against you. Because the guy at the frat party who saw the ice luge and saw the guy on the table and fall down, hit his head, and the ambulance came, he can't be cross-examined because you know who came to the courtroom? His friend who wasn't there. You see? So there's not only this issue about reliability. We don't like statements that go through different people. It kind of degrades what was first said or observed, gets filtered and distorted. The other reason is it violates the right to confront the witnesses against you. So in a child abuse case, right, if little Daniela said that her grandpa from Sicily came in her room and he scares her and he touches her on her body, and little Daniela doesn't come to court but her counselor comes to court, it's not going to work. Because the accused, grandpa's got a right to challenge the witnesses against him. He's got a right to look the witnesses in the eye. He's got a right to question the witnesses. Remember, we learned all about the right to confront. It includes, for the most part, the right to look the little girl in the eye and ask her questions. Now, maybe Crandall applies where she can be on video or FaceTime, okay? But he's still got the right, Grandpa, to ask her questions. You can't say, well, she's not coming. We're gonna have the counselor say what she said. No. No. You may not be entitled to a perfect confrontation, but you're entitled to a real-time confrontation, okay? We don't want to look the counselor in the eye. We want to look the accuser in the eye, okay? Anne Boleyn doesn't want to look all those men there who set her up to get executed. She wants to look in the eye the people who said she did bad things at court. Go ahead.
If hearsay is corroborated, does that, you know what I mean?
No, it doesn't fix it. There may be exceptions to the hearsay rule that require corroboration in order for the exception to work. So corroboration sometimes matters, but it's not a general rule that, well, if there's a witness to the thing, 2 witnesses, it's not hearsay. No, it's still hearsay. Or, we look at pictures and the guy is on the floor at the frat party and his head is cracked open. And it was an ice luge, and it was a table. And the picture shows what the guy remembered, his friend telling him. No, the friend's got to come. The dude who lived it's got to come. Unless there's an exception, which we'll talk about in a little while. But you can see that in the criminal world, in the criminal case, it makes a lot of sense that we don't like hearsay because it takes away your right to confront the witnesses against you. And that's not okay. Poor Anne Boleyn would love a hearsay rule in 16th century England, but they didn't have one. So she died unnecessarily. So 2 things you need to think about, you need to write in your notes. Hearsay is not reliable, and it violates the right to confront the witnesses against you in the criminal courts. It violates that 6th Amendment. Now I'm going to give you another example of child abuse, and I don't think that I used this example in your discussion boards. Maybe I did. I don't think so this semester. But a few years ago, one of the most prolific running backs in the history of the NFL was a guy named Adrian Peterson. Adrian Peterson played football for the Minnesota Vikings and then later was traded, but most of his career was with the Vikings, and he was a multimillionaire and a celebrity and a tremendous athlete. Well, he was from Texas. I think he was from West Texas, but he played in Minnesota. Well, when he was home and it was not football season, he was with the children that he fathered, and the mom allowed him visitation, which was appropriate, at his mansion. And the little boys, one of whom was 5 or 6 and the other was a little older, there might have been other kids there. But the little one, who was maybe a first grader, maybe a kindergartner, I forget, but he was little. He did something bad, something silly, something little kids do. And Adrian, to punish him, had the boy go get a switch out in the woods. And I may have talked about this in the past, what a switch is. It's a stick. We talked about corporal punishment. Adrian believed in corporal punishment. I'm not so sure the punishment fit the offense. We might have talked about this case earlier now that I'm remembering. But in any event, the little boy went and got the stick. And then Dad had him pull down his pants and he beat him about the butt at the scrotum, privates. Just terrible, terrible, terrible. They didn't charge him in the beginning, and then they wound up charging him when somehow the news got hold of it. And all of a sudden the prosecutor's like, oh yeah, we should have charged him. And then he gets indicted and they figure out the case. Here's the thing. Imagine the Adrian Peterson case unfolded like this, and I'm making it up. It's a hypothetical. Pay close attention so we understand the hearsay rule. So now, imagine Adrian Peterson's neighbor, quote unquote, saw the whole thing. Saw the whole thing. And you're the social worker, or you're the investigator that's got to go out and see if Adrian Peterson was appropriate in disciplining the little boy, or he did something really bad that was child abuse or excessive corporal punishment. You're the investigator. You go out and you learn from your supervisor, the neighbor saw the whole thing. So you go out with your notepad and your pen and your tape recorder maybe these days, and you find the neighbor and she says, oh yeah, I saw the whole thing. Oh my God. He hit with a tree branch and he whooped him and the boy was screaming and then he stuck leaves in his mouth so he couldn't speak. Oh, write that down. Write all that down. That sounds horrific. Okay. Now comes the trial. And the prosecutor says, or the deputy attorney general says, oh, we're going to put you on the witness stand. When I say you, I'm referring to my students in the class right now. You're the investigator. You're the social worker. We're not putting the neighbor on the stand. She's a little wacky, by the way, but maybe that's motivating us. We want to put you, the social worker, who did really good at Montclair State. You got all A's, okay? You went in the grad program, and they want to put you on the stand because you have a halo, you know? You're a social worker. You've done good. You advocate for kids. They want to put you on the witness stand. Well, if it's a criminal case, it ain't happening, right? It ain't happening because, okay, the defendant, Adrian Peterson, the famous football player, has got an absolute right to look the neighbor in the eye and go, what did you say I did? Well, through his attorney. He's got a right to confront the witnesses against him. And you may say, well, what's the big deal? What if the lady testifies and I testify, meaning you? You're the investigator, social worker, detective. No, it's still hearsay, okay? It makes it a little less offensive because the lady's going to be there, but it's still hearsay. It's an out-of-court statement offered in court for the truth of the matter stated by someone other than the person who said it. Gabby?
What if the lady dies?
Doesn't matter. Gabby says, what if the lady dies? Doesn't matter. In civil court, it might matter, but in criminal court, it wouldn't matter. There are exceptions, though, I'll share with you, though. Again, I'm talking about the criminal case now. But if there's a death of a declarant in the civil courts, there may be a workaround. But in Adrian Peterson's criminal trial, for which he was indicted, you got to bring the neighbor in. And you might go, well, what's the big deal? We just played telephone and it worked perfectly. At least the second half of it was exactly what Nico said. Well, it is a big deal. I'll tell you why. Imagine you're the worker and you're on the witness stand, and I represent Adrian Peterson, okay? And I come up to you, may I cross-examine you, Carly? Carly, my understanding is you work for the Department of Child Protection. Is that true? Yes. And were you assigned the investigation into the alleged child abuse by Adrian Peterson at his mansion in West Texas?
Yes.
Yes. And my understanding is you went out and interviewed the neighbor who lives next door to Adrian Peterson about what she saw that day involving the child and the punishment. Is that right?
Yes.
Did you take notes when you interviewed her?
Yes.
Do you commonly take notes when you interview people as a social worker?
Yes.
Okay. Do you have those notes with you today? Okay. I want to ask you some questions about what the neighbor saw because you interviewed her and you wrote down good notes, I assume, right? Were they good notes?
Yes.
Okay. How far away from Adrian Peterson was the neighbor standing? Only if you know. Do you know?
No.
No, you don't. That's okay. We just wanted the truth here, okay? Did you happen to ask the neighbor if she has any vision problems? Yes or no?
Yes.
You did? Does she have any vision problems?
No.
Did you check with her doctor? Yes or no?
No.
You took her on faith that she has no vision problems.
Yes.
Would it surprise you if I told you that when the police interviewed her, she had a pair of glasses around her neck? Would that surprise you?
Yes.
Okay. Are you familiar with the lawsuit that the neighbor has pending against Mr. Peterson? Are you?
No.
Okay. They live next door to one another, is that right?
Yes.
Did you ask the neighbor if she had any negative feelings about Mr. Peterson when you interviewed her? Yes or no?
No.
You did not. How long was the switch or the stick that the neighbor claims that she saw?
I do not know.
You didn't think to ask her how long the stick was?
No.
Okay. She would know the answer to that, I assume, right?
Yes.
Because she said she saw the whole thing.
Yes.
But we only have you today.
Yes.
Good job, Carly. Thank you. I'm not going to play around any further. But do you understand what I'm talking about here? Could she see? How far away was she? The fact that I made up a lawsuit, maybe they're fighting over a boundary. He's always put his fence on my side of the land. Just because he's rich and famous, he thinks he can encroach on my land. I hired a lawyer. Damn right, I hired a lawyer. She told you. You better write that down. That shows bias, right? Bias. We don't know if the neighbor's got any bias. What does bias mean? She don't like him. And if you don't like somebody, you might pay the bill a little bit. You might embellish. You might take a 4-inch stick and make it a 10-inch stick. You might not be able to see what's going on there. It kind of looks like he's shoving leaves in his mouth. I don't know. That's a really weird thing to do, too. That's in the case. I'm a little suspect of that. It's that bizarre. But it could be true. I wouldn't want to interview Carly about the leaves in the mouth. That is so disturbing. You know, I want to interview the lady who claims she saw the leaves shoved in the mouth, right? Because it's odd. It's really... Listen, I'm not going to defend assaulting a child. You know how I feel about child abuse. You should never strike a child to get them to do what they want. But I understand that culturally, belts and sticks and shoes and all kind of stuff in the old days, right? We don't endorse that now. But some of our parents came from the other side with different cultures from the South, from Europe and whatever, and they looked at the world differently. It's not okay. So I could see the switch and all that, and part of the terror was he made the boy go get the stick. You know, in the Italian culture, you had to go get the belt. Not a good, you know. It's horrifying. Not okay. But the leaves in the mouth, I'm suspect of. That's an oddball detail, and it could be true. But I don't want Carly. I want the lady who said she saw that, because that is a jury's going to convict my guy in 2 seconds if he did that. You know, the stick and all that, you might have a couple of jurors and go, well, you know, when I was growing up, my father did this, and my aunt did that, and this, that, you know. Maybe it wasn't 6 inches, she doesn't remember how far away, she's mad at him. You know, you can get a not guilty verdict. Maybe appropriately so. But if the jury believes that Adrian took leaves from the dirty ground and shoved them in his 6-year-old son's mouth while he beat him with a stick on his scrotum, he's going down, bro. He's going to jail. So it matters, right? So I wouldn't want Carly there. I would want to challenge, I would want to question the lady who lived it. Okay? So, number one, Carly's testimony violates the rule against hearsay, because the statement was made at the neighbor's house to Carly, and she took nice notes, very good notes. So was a statement made outside the courtroom, offered in the courtroom by someone other than the person who lived it, who experienced it. Carly, the social worker. She wasn't there. She's just telling us what someone else told her. And intrinsically, that's not okay, because it's unreliable, because it came through, filtered through her brain and her expectations and her feelings about sticks and switches and football players and all that, you know, not the neighbor. And number two, it violates the Sixth Amendment's right to confront the witnesses against Adrian Peterson. Go ahead.
So, if in this scenario, then if you do get the neighbor, would there be any reason to question the social worker as well? Maybe to add, you know what I mean? Like, would there be any reason to question this, put the social worker on the stand, or would you to support?
Yeah. The answer to that, again, we're getting to very specific criminal procedure, which I happen to know much about from being a trial lawyer, but the answer to that is generally no, except the exceptions involve, suppose we had Carly's report and the neighbor said something different. Oh, it was about a 12-inch stick and it was one of those rose bush sticks. It had, what do you call those? Thorns. And then you're like, ma'am, hold on a second, says Adrian's lawyer. Are you saying that the boy was beat with a rose bush stick with thorns on it? That's right. Now we have Carly's report, and she doesn't mention anything about thorns or a rose bush. So we could bring, the other side brings Carly in, okay? Or even the prosecutor, who's now very sad that his witness changed her story. He might talk to Carly, to his detective or investigator, go, what the hell well, she said something about a rose bush, but I didn't write it down. Okay. Well, then maybe we'll bring in Carly to explain she mentioned it, but it was unclear what she meant, so I didn't write it down. Whatever. So to answer your question, you wouldn't put Carly in to repeat what the lady said she saw. You'd bring her in if there's an inconsistency or something that needs explanation that the lady was unable to explain. But you just can't pile on as corroborating. You're not really corroborating anything. Other than you're saying, well, she said it then and she said it exactly the same way before. You're really not allowed to puff up your witnesses. When you put your witness on the stand, the expectation is that they're going to be honest and truthful. We don't need Carly to come and go, yeah, she told me the same thing. You got to believe her. Now, if her credibility is attacked, if she's on the witness stand, the neighbor, and they go, you just made this up because you can't stand Adrian Peterson. You're mad at him. Him and his wife have been mean to you, and you've been mean to them for years. In fact, you changed your story completely today. Isn't that true? No, sir, I did not change my story. If the lawyers for Adrian suggest to the jury that the lady who's the neighbor changed her story, then you can put Carly on what we call a prior consistent statement. Basically what you were asking about before, but only in that very narrow scenario where the lady is attacked as changing her story today in the courtroom. You just made that up on the witness stand. No, sir. Yes, you did. Bring in Carly. Well, I interviewed her. She said the same thing 6 months ago. Boom, Carly comes in. Okay, this isn't a law school class, but that's the way it goes down. I just want to, but that's a great question, and I want to focus on hearsay. We're looking at the definition of hearsay. I explained the rationale for hearsay, right? Because hearsay is considered unreliable, like the game of telephone. And number two, it violates the Sixth Amendment's right to confront the witnesses against you in a court of law. Some people say, and I alluded to this earlier, well, if you bring in the video recording of the little girl, isn't that better? Well, it's better, but it's still hearsay. Well, why is it hearsay? You have a video of what actually happened. It's like having a ring video of Adrian Peterson with the stick and the leaves. Why do we even need her? Well, how about this? And this is the test for whether hearsay is hearsay or not. The video, yes, is more compelling than someone's memory, but if you put the video or the file or the laptop on the table here and you ask it questions, will the video answer you? No. Carly could have took out her phone and recorded her interview with the lady, the neighbor, in 4K. Beautiful 4K living color. Okay, beautiful sound. She could play it back on a 100-foot screen. Because look at that. Carly's, not only do we not have to worry about Carly misremembering stuff, there's the neighbor, 70 foot high. Okay, says me, the lawyer for Adrian Peterson. How far away were you when you say that my client hit the child with the switch? Judge, it's not answering me, man. I don't know. I think this violates the rule against hearsay. Because I can't confront the witness against me. I'll try again. Ma'am, maybe I'm not being loud enough. How far away were you when you said you saw my client strike his child with a... Judge, I think this is a problem here. All right, Del Russo, cut the theatrics. Obviously, it's hearsay. I'm sanctioning you $50 for being a jerk. I'm going to introduce the idea of hearsay exceptions, and then Thursday we will explore them in great detail. But before I do that, so I spent a fair amount of time telling you that we don't like hearsay. It's not admissible in the courts. It's bad juju. It's unreliable. Violates the sacrosanct, the sacred Sixth Amendment of the Constitution. Not only of the United States, by the way, it violates the New Jersey State Constitution. However, there are a bunch of exceptions. And I may even share one exception with you and see whether you can explain why that exception exists before we break until Thursday. But the courts, even though they have recognized that hearsay is something that's problematic, and for centuries they've declared it inadmissible in court, they've also recognized for centuries that sometimes hearsay is admissible. And I think Gabrielle asked, what if the person's dead? Not an exception, but that's a good observation. There are other exceptions that arise because of the particular circumstances of the declarant, the person who said it. It's not the death. But almost death is an exception, which we'll talk about maybe Thursday. I don't know about now. But here's the thing about the exceptions. When I teach you the exceptions on Thursday, and I'll give you one before we leave, the reason that the exception exists, that we allow that hearsay in, okay, is because we have concluded that some statements are more reliable than other statements based upon the context of how they were said. Like what was going on when they said it. When the neighbor said she saw Adrian Peterson strike his son with a stick and all that, what was happening? How was she behaving? Was there something about how she said what happened, how she explained herself, that makes it more reliable than the average statement? Okay? I'm going to give you one right now so you appreciate this. We worry about people who make statements outside the courtroom that aren't in the courtroom to be questioned. We worry about that because the person who's in the courtroom, right, they might not appreciate or understand that the person who made the statement's got a motive, they have a boundary dispute, they don't like the guy, they may have been half paying attention, okay? The person who repeats what someone else told them may not appreciate or understand what the perspective of that person is. They may have a motive to lie. There's a lot going on, right? But sometimes the person who makes a statement outside the courtroom, and it's offered in the courtroom by someone else, has a really important reason to get it right. So we worry about Peterson's neighbor lying or embellishing or not telling anybody she wears glasses because she wants to be in the news at night or whatever. Okay? Because she's had time to reflect. So think about that. But sometimes people make statements in a particular context, in a particular way, in a particular space, in a particular relationship, where the courts have said, well, that kind of statement's more reliable than two people standing, at the bar at the Casey O'Toole's pub. One example. Statements made by a patient to a doctor for diagnosis. So let's unpack that. The courts have said when people make statements to their doctor in expectation of a diagnosis, those statements are more reliable than the dude who was talking to his frat buddy who said what happened at the frat house about the guy fell off the table and cracked his head and they were doing ice blue shots. The guy who told his buddy about what he saw at the frat party, he doesn't have an obligation to tell the truth. He doesn't have a motive to tell the truth. He could have half been paying attention. But when we go to the doctor and we want treatment, we want a diagnosis, the courts have said those statements, they are likely admissible. Doesn't mean they're 100%, but we let them in most of the time. But it has to be a statement made to a doctor for purposes of diagnosis and treatment. Why do you think the courts have made an exception for statements we make to doctors? Why do you think this exception exists? Because remember, we're worried about people embellishing, lying, misrepresenting. Go ahead. You have your hand slightly up. Is that it? You want to tell us?
Oh, I was just gonna say maybe the person is like incapacitated and can't speak for themselves. So like if it's a realistic case and the doctor, they told the doctor this specific thing.
Okay, you know what? You're kind of tracking what Gabriella said. Gabriella said the person's dead. You said the person is incapacitated because they're at the doctor's office. That may work in the civil courts, but not in the criminal courts. It doesn't make the statement more believable. The person who made it is most likely not lying. You know, the dude at the frat party who tells, oh, you should have been there. It was rad. Oh, whatever you guys say. That guy, fat illusions. Oh my God, it was the best party ever. Is his statement any more likely to be true? In fact, it's probably more likely to be embellished or infected by the prism of alcohol than other statements. But when you go to the doctor and you want treatment for what ails you, you want a diagnosis and treatment, the court says, well, those statements, they're a little more reliable than your average statement. Go ahead.
Well, I think two things. One, because if you're actually seeking treatment and you want treatment, you need to tell the doctor what happened, like, and the truth, so that they can provide you the correct care so you feel better. Second, if you make up a story that then when the doctor examines you, it doesn't check out, like, you know, there's also stories too where like the doctors can, you know, if there was like a physical injury and they're like, well, this fracture couldn't have happened that way or something like this. Like that's not, like, it's what we're finding and what you're telling me don't match up, you know? So
Yeah, I've never thought about that part too. That's excellent. That's excellent. And Alex is right. The expectation is when you go to the doctor, you have a tremendous motive to be honest, right? If you were getting shooting pains in your stomach, and you're like, this sucks. I can't even go to the party this weekend. It's hard for me to drive. I got to go to the doctor. Tell me what's going on. Your mom said that you're in a lot of pain and all that. Yeah, whenever I move my neck this way, it hurts. Why would you say that? You have a motive to tell the truth because you want the shooting pains in your stomach to stop. Why would you lie about that? You wouldn't. You have a motive to tell the truth. And Alex says, not only that, unless you're a dum-dum, you know the doctor might be able to prove that you're making it up or lying or being deceptive, and now you're breaking the relationship, and you could be exposed as a fibber. So that would create an incentive not to lie, because you know the doctor, you know, like, how about this one? Have you been sexually active? No. Now, I don't know that the doctor, I taught you that doctors really can't tell that. In some ways they can. If you have an STI, almost always they can tell. But, you know, have you been smoking? No. And you smile and your teeth are like bright yellow. Well, you know, tea. I drink a lot of tea. So to your point, Alex, right? You can be exposed by the doctor. But the most important reason is that the person who goes to the doctor in need of treatment is more likely to tell the truth because they want to get better. Just like Alex said, you want to get better. You want the pain to stop. Now, could you lie? Yeah. Do people lie to their doctors? Yes. Usually about lifestyle. I don't smoke. I've been getting plenty of rest. You know, oh no, I'm gonna eat veggies every night. Yeah, okay. You know, you've been not eating at McDonald's every day. Oh no, put those fries away. People lie about that lifestyle, right? Smoking, drinking, and everything else. Our vices, if you will. But if you're in pain, so there is an exception called the medical diagnosis exception to the hearsay rule. And sometimes that exception is relevant in child abuse cases. It's relevant in any case. But in child abuse cases, a lot of our kids go to the doctor because we want to make sure they're well. Okay? We want to make sure they don't have an STI. We want to make sure that they didn't suffer some physical trauma that might impact their health or their ability to procreate or have babies or whatever. Right? If it's an adolescent, we're concerned about pregnancy. If they're post-pubertal, we're concerned about pregnancy, STIs, injury, right? So they go to the doctor. Now the moms, they want to know, was she touched? You know, doctors really can't tell you that. We talked about that. But nevertheless, all kids who are suspected of being sexually abused go to the doctor. And that might be an opportunity to get some hearsay admitted that helps corroborate the child. Somebody said, can you bring in the Carly to testify and the lady neighbor who saw everything? And I said, generally no. It was Alice. Generally no. But sometimes there's an exception to the hearsay rule, and you might want to put them both on the stand. The child on the stand and the doctor, who tells us what the child said. I'm going to give you an example, and we'll close with this. I tried a case once. The guy's name was JT. The girl was 14 years old. And the reason I really was going hard and heavy after JT was he had prior molestations. And his MO was he would hook up with single moms who had children that were 12, 13, 14, and he molested them. He had a couple of cases that he beat. And I had him. And maybe he got probation on one, the other one got dismissed for whatever reason. So I got him now. I'm like, this JT, John Thomas, I'll say his name. He molested 14-year-old girl, we'll call her Danielle. But all the players here were Jehovah. Their faith was Jehovah Witness. And through the prism of time, I don't remember everything about this case. And I certainly don't know much about Jehovah Witnesses. So if that's your faith, I respect it. And if I get something wrong, direct message me and I'll cure it next class. But what she said to me, right or wrong, the mother and the 14-year-old girl is, oh, he did these things, but I'm not testifying. What do you mean you're not testifying? You have to testify. Oh, no. We can't swear against someone, and I need to take an oath, so I cannot swear, nor can I give testimony against another. That's my faith. Forgetting about I tried everything under the sun to get around that. Bring in Jehovah experts, faith-based people, this, that, and the other thing, social workers. Nothing worked. She wasn't testifying. So I said, you know what? She went to the doctor for the very wellness exam I described to you. Dr. Sands, who's my colleague and friend, let me go get Dr. Sands. There was the report. And she said, oh, my mom's boyfriend, John Thomas, came in my room and he made me put it in my mouth and he did this and he did that. She described the molest. Gotcha. Here's the confounding variable. Let's see how sharp you are. Judge Womack, first of all, I had to put the doctor on the stand and the nurse. I had to prove to the judge that the exception applied, that it was medical diagnosis for treatment, okay, that you have to show that a person went to the doctor with the expectation of a diagnosis and treatment. So I put the doctor on the stand, I put the nurse on the stand, I put everybody I can get from St. Joseph's Hospital on the stand. Judge Womack said, I'd like to help you, Mr. Del Russo, but denied. I figured out another way, so all was not lost. I put him in jail. And I lost, deservedly so. I'm going to give you one fact. Every 2 weeks we meet with a team. When I say we, the prosecutor, child protection, deputy attorney generals, 12 people get around the table. And they go, what are the cases from last month? State versus Del Russo, State versus Artist, State versus Festa, State versus John Thomas. DIFUS worker, how's the kid doing? She's doing really well, but she hasn't gone for her medical exam yet. It's a month and a half later. Why isn't she going for the medical exam? I don't know. They're giving me double talk. Every time I call the hospital, they say they canceled again. I go, send a car to go get her, bring her for her medical exam. Me. Del Russo messed up. And they did that. The division, the social worker, Carly went out there with her car. And they were the lovely, Carly, how are you? They were very empathic, empathetic. I'll get in the car. They took her there. The kid got her little exam, and she went home. And I made my argument in front of Judge Womack, and he said, nope, not coming in. Why? Why did I lose the medical exception before Judge Womack? Someone else. Go ahead.
Because she did not go there on her own. You would say
Meaning she did not go there for what?
she did not go there for a medical diagnosis.
Which is the motive, to be honest, right? She just went there because Carly showed up with her limousine and her chauffeur and said, get in. I've donated all my time, now that I'm a billionaire, to helping kids. Get in the car. We're going to St. Joe's. You can get an ice pop afterwards. Not now, after. I'm teasing. That's it for today. We'll regroup on Thursday. All right?